Good morning, good afternoon, and good evening. Welcome to Seminar F of the Monique and Roland Vale People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is the right to peace. Peace is not simply the absence of war. Peace requires that all states refrain from interfering in the internal affairs of other states, that they settle their disputes peacefully through negotiations, arbitration, and settlement, and that they create conditions necessary to eliminate the causes of international conflict, including an end to the arms race. The right to peace is inherent in the very fabric of the United Nations Charter. Through the Charter and subsequent UN resolutions, the human right to peace is ripening into a norm of international law. In 2016, the General Assembly adopted the UN Declaration on the Right to Peace. The right to peace is the right of peoples to demand the realization of peace from states. The right to peace also extends to discrimination and economic disparity, which are causes of war. It is the right to modify traditional involvement of states only in peace and security matters. This represents a paradigm shift from state-oriented peace and security to people-oriented peace. At the same time, as a legal human right, the right to peace has been developing as state practice in some countries, where the right to peace or the right to live in peace has been incorporated into constitutions and judicial decisions. We are particularly challenged today, the right to peace is challenged with wars around the globe, particularly the genocide that Israel is perpetrating in Gaza. This seminar will provide information and explain the significance of the right to peace, the international movement initiated by non-governmental organizations or NGOs, and developments in several states. We have French, Spanish, and English translation. If you click on the interpretation button at the bottom of your screen and select your language, then you will hear interpretation of the program into that language. Please put your questions in the Q&A box for our discussion following the program. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. Our faculty for this seminar includes Richard Falk, Carlos Villan-Duran, June Sasamoto, and Roberto Zamora. Each of them will speak for about 25 minutes. They will then comment on each other's presentations, followed by Q&A with registrants. Richard Falk is Albert G. Milbank Professor Emeritus of International Law at Princeton University, where he was an active member of the faculty for 40 years, from 1961 to 2001. He was also chair of Global Law, Faculty of Law at Queen Mary University in London from 2021 to 2025. Richard served as the UN Special Rapporteur on Human Rights in Occupied Palestine from 2008 to 2014. His most recent book, written in collaboration with Hans von Sponeck, is Liberating the UN, Realism with Hope, which was published in 2024. His book, Genocide in Gaza, Global Voices of Conscience, was co-edited with Ahmet Davutoglu, and his book, Patriotism to the Earth, was written in association with Sasha Milanova. This endangered planet in 1972 was selected by the journal Foreign Affairs as one of the 6 most influential books published in the last century, and that books that address global issues. In 2016, Richard published a book of poems under the title Waiting for Rainbows. His memoir, Public Intellectual, The Life of a Citizen Pilgrim, was published in 2021. Richard has been nominated for the Nobel Peace Prize several times since 2008. He currently serves as president of the Gaza People's Tribunal. Richard will discuss the right to peace. Was it ever meant to be? Carlos Villan Duran is professor of international human rights law at a number of universities in Spain, Mexico, Argentina, and Uruguay, and he was chair of the drafting committee of the Luarca Declaration on the Human Right to Peace. Carlos is an honorary member of the Chair on Human Right to Peace at La Plata University in Argentina, and he has received an honorary doctorate from the University of Chiapas in Mexico. He was president of the Spanish Society for International Human Rights Law and a former staff member of the Office of the UN High Commissioner for Human Rights. Carlos is the author of 197 pieces on international human rights law, including 21 books. Notable examples of his publications are Curso de Derecho Internacional de los Derechos Humanos, La Declaración de Luarca sobre el Derecho Humano a la Paz, the International Observatory of the Human Right to Peace, The Emerging Right to Peace, Its Legal Foundations, La Paz es Nuestro Derecho, Le Droit Humain à la Paix, Revista del Instituto de Estudios para la Paz y Cooperación, The Impact of the United Nations Human Rights Treaties on the Domestic Level, 20 years on, Civil society organizations' contribution to the Universal Declaration on the Human Right to Peace, and the Human Right to Peace, a legislative initiative from Spanish civil society. Carlos will discuss international politics and the normative situation. June Sasamoto is a lawyer and president of the Confederation of Lawyers of Asia and the Pacific, COLAP, and he serves as an IADL bureau member and a task force member of the People's Academy. June devoted himself to establishing the UN Declaration on the Right to Peace in the UN Human Rights Council from 2008 to 2018, and he researched the implementation of the right to live in peace in Japan and in other countries. June earned his PhD in the right to peace from the University of Tokyo in 2025. His doctoral thesis finds the meaning of the right to peace in the security theory of international politics by analyzing the discussion in the UN Human Rights Council. June will discuss the international political and legal meanings of the right to peace through analysis of deliberations in the UN Human Rights Council. Roberto Zamora earned his master's in international law from the University of Peace, and he is currently a PhD student at the University of Helsinki. Roberto successfully litigated on the basis of violation of the right to peace against the decision of the government of Costa Rica to support the US-UK-led coalition that invaded Iraq in 2003. Roberto also successfully litigated against the manufacture of weapons in Costa Rica, achieving recognition of the right to peace in Costa Rica. Roberto has participated in multiple fora and conferences on the right to peace. He co-represented the IADL, International Association of Democratic Lawyers, in Geneva in the process related to the Declaration on the Right to Peace. Roberto will discuss Costa Rica and the right to peace, vindicating sovereignty and self-determination. We will begin our program with Richard Falk, whom I must add is also a member of the Scientific Committee of the People's Academy of International Law. Richard?
Thank you, Marjorie. It's a very challenging topic for our seminar today, and I'm glad to be part of this distinguished panel that I believe will sophisticate us all in the complexity that underlies the right to peace in a world that sees very little evidence of the impact of peace-minded thinking on the way in which governments act and many movements in society behave. So it's a very tricky conceptual issue that raises for me the central question of what does the right to peace that has been given a lot of attention by the UN and by international experts on world politics and international law, raises for me this question of what does it add to our understanding of how the world is constituted and works? Is there really something added by the pedagogical emphasis on a right to peace? And it seems to me important to question whether the language of the right to peace is appropriate, given the realities, first, of the fact that it's not clear what tangibly has been done to, over the 80 years that the UN has existed, to implement the promises of the UN Charter in its famous language in the Preamble to save succeeding generations from the scourge of war. We witness these prolonged wars in Ukraine and Gaza, and we see very little impact from a imperative to serve the interests of a peaceful world. And so I think we have to approach the topic with some skepticism. Is it a expression of wishful thinking, or is it truly operative as a guideline rather than merely an assertion of an aspiration which is not being materialized in the behavior of states and other political actors? And we notice that there's also ambiguity in how we think about the right to peace. Marjorie, in her introduction, in a sense, overlapped the two main sets of ideas. The most common view of the right to peace was the subject of an original UN declaration in 1984, which associated the right to peace fundamentally with the effective elimination of war from the human condition. The declaration stressed the fact that the peoples of our planet have a sacred right to peace. What was meant by the word sacred is rather mystifying. Is it something beyond law and morality? And is it a way of saying that peace is so important that it should be endowed with a spiritual identity and not thought of as a normal rule of law or even a moral imperative? So I think that's in the background, and we can ask also, how has the international system implemented this so-called sacred right? And as Marjorie also alluded to in her introductory remarks, it was originally thought in terms of the behavior of states and a state-centric world, and gradually has been expanded to include international actors that are associated with the international institutions, above all the UN, but also regional actors. And Latin America has been particularly active in promoting both the language and the introduction of the concept of a right to peace into its constitutional domestic structure. And that's, again, interesting as a development, and it's fortunate that we have an exposition of the Costa Rican attempt to be an exception to the modalities of behavior that are characteristic of other states, particularly the important states. And we have to wonder why, if the UN was determined to save succeeding generations from the scourge of war, it designed an organization that gave the most dangerous countries in the world an exemption from compliance with the Charter and with international law generally, in the form of the veto. And what that has meant is, over the years, is that war and peace has been controlled fundamentally by these 5 major actors who also happened to be the first 5 countries to acquire nuclear weapons. So you have a situation where the design of the organization to uphold peace is ambiguous itself about the nature of global security and gives primacy to geopolitics, which we see in evidence in both of these unfortunate and prolonged and devastating conflicts, the war in Ukraine and the asymmetric war in Gaza, and now spilling over into the region. What led to this kind of tension between the way world politics has evolved under the influence of political realists who consider war embedded in the human condition and are very skeptical of even the most validly ratified international agreements and treaties, covenants. If you think of the world as it's seen by Machiavellian practitioners of foreign policy for the important states, Henry Kissinger would be one example. They are extremely dismissive of any consideration of law, morality, or even more so, a right to peace in the definition of national interests and strategic ambitions. And so, interestingly, the UN has navigated from its 1984 Declaration on the Right to Peace, which emphasized three elements: the elimination of war, the renunciation of the use of force in international relations, and the obligation to secure peaceful settlements of disputes. This is a negative view of the right to peace, which emphasizes war prevention and looks at the immediate conflict potential of disputes among countries. And that view, that image of the right to peace was superseded by the Declaration of 2016, which adopts a positive conception, a positive peace conception, which means, which is spelled out in the Declaration as embodying a whole agenda of aspirational goals, including the right to development, the satisfaction of fundamental human rights, the prohibition of terrorism, and the general view of seeking to associate peace with the preconditions of peace. That is, if you have a human rights culture that is effectively implemented in behavioral patterns, then the recourse to violence will be automatically curtailed in such a way as to promote a peaceful world. There is also in this more elaborate 2016 declaration a major ambivalence as to whether force is uniformly rejected or whether it gives way, as another important UN document, the General Assembly Resolution 2625 on peaceful relations among states, where wars of national liberation, anti-colonial wars, anti-apartheid conflicts are effectively exceptions to the prohibition on the use of force, and allow that to be introduced into the notion of the right to peace. So the right to peace includes recourse to force in the face of severe injustice. And the situation of the Palestinian people confronted by a period of settler colonial apartheid that became a genocidal assault on the civilian population of Gaza and now West Bank, is a view of violence that contradicts every fundamental conception of law and gives no deference to the right to peace. If there was a viable right to peace that was existentially relevant, one would expect governments of the world and other political actors to do whatever they could within their capabilities to stop that kind of violence and to support the struggle of the Palestinian people for their basic rights, including self-determination. Instead, you find the liberal democracies of the West, particularly the former colonial powers in Europe and the breakaway British colonies in North America, Australia, New Zealand, supporting a transparent genocide, and their governments punishing those who name it genocide, name this violence genocide, or who express solidarity with the Palestinian people. So what I'm trying to suggest is that we have to think critically about what is contributed to international discourse of a positive sort by contending a right to peace is being implemented in a world that is not able to deliver the narrow conception of peace, much less the positive peace notions that incorporate human rights and basically examine the deep roots of violent conflict. And so we're confronted by that puzzle. What do we gain from the right to peace as a discourse? Has it really had a positive effect on human consciousness or the behavior of states or the capabilities of the United Nations? I stop with those kinds of questions uppermost in my own mind, and I think deserving of thought and reflections from others as well. Thank you.
Thank you so much, Richard, for your critique of the historical development of the right to peace and the realpolitik disconnect between the right to peace in theory and in practice. Our next faculty member is Carlos Villan Duran, who will deliver his remarks in Spanish. Carlos?
Thank you. Thank you very
Oh,
much.
gracias. Thank
Es
you.
un placer
It's a
para
pleasure
mí,
for me to be
acompañar
here with you
esta reunión de la
in this meeting
Academia Popular
of the
de Derecho
Popular
Internacional
Academy of
y
International
felicitarles
Law.
por
I want to
haber escogido
congratulate
el
you
tema
to actually
del derecho a la
choose
paz en
the
estos
right of
momentos
peace
en que
in
el
these
mundo
moments where
está
the world
atravesando
is
por
going through
una
a
crisis
crisis
en las relaciones
in the
internacionales
international
de una
relationship
profundidad
that is really
sin
deep
precedentes
and
en la historia,
unprecedented in
cierto
history,
menos en las relaciones
and that
internacionales
has to do with
desde décadas,
international
desde el
relationship,
año
and that
1945,
has
en
changed with
que se
1845,
adoptó la Carta de las
1945,
Naciones
when
Unidas. Y es que la crisis actual
the United
es una
States
crisis que
statutes
pone
were
de
adopted.
relieve
The
el
current
agotamiento
crisis is putting the
del modelo
tiresome model
de comunidad internacional
of the
que
international
organizó
laws
la Carta de la, y creó y puso
that
en pie la Carta
organize
de las
the
Naciones
United
Unidas
Nations
en el año 1945.
and ratify the
Si
1995
nos fijamos
Charter in
en
1945.
la
If
situación
we pay
actual,
attention to
es
the
que
current situation,
la nueva
the new
administración del presidente
administration
Trump en
of
Estados Unidos,
President Trump in the
que
United
asumió
States
el 20 de enero
that
pasado,
started
ustedes
in
saben,
January
ha
20
dinamitado
had
el orden
exploded
multilateral
the
que
bilateral
surgió tras la
work
Segunda Guerra Mundial
that he
bajo el
was doing in
paraguas de las
1940
Naciones Unidas,
under the umbrella
despreciando
of 1940
su
is
filosofía,
being against
sus
its
fines
philosophy and
y
its
las
objective
normas
and the
del derecho
norms
internacional
international
pactadas
law
en los
that
últimos
were
80
have
años.
been implemented in the last 80
De manera que
years.
estamos en una situación
Currently
crítica,
in a critical
actualmente crítica,
situation right now,
mundo, dominada claramente por
we're,
una
we're
proliferación
seeing a
de
proliferation
conflictos armados no controlados.
of armed conflicts that are not controlled.
Hoy ya se reconoce
Right now, we're
que hay
recognizing
120
there's
conflictos armados
120
en curso en el
armed
mundo.
conflicts in the world
Nos
currently.
fijamos habitualmente en las
We
guerras de
look in the
Ucrania, en
Ukraine
las guerras en
war,
Oriente Medio,
the
en el genocidio
the
palestino,
genocide in Palestine, the
pero
Midwest wars,
además
but all
hay
besides
otros
that,
118
there's
conflictos
another
armados más en el mundo
118
que
other
pasan casi
conflicts that are
desapercibidos
almost not
porque
being
no son
noticed
noticia, no son noticiables
because they're not
en
news.
los
They're
medios
not
más
headlines currently.
Si hay tanto conflicto
If there's
armado
so much conflict
incontrolado,
in the world and
eso quiere
armed
decir en
conflict in the
términos
world uncontrolled,
de derecho
what does it
internacional
mean in
que hay una
terms of
violación
international law?
sistemática
There is a
de la
systemic
Carta de las Naciones Unidas
uh,
y de los principios
things of the
básicos que
basic
ponen en
principle of
pie
the UN
la
Charter,
Carta de las Naciones Unidas, entre ellos el
among
principio de
them
la prohibición
the
del
principle
uso
of
de la fuerza
prohibition
y
of
la
resources,
obligación de arreglar los conflictos entre los estados por medios
conflicts of the states,
pacíficos y
try
de
to work on
conformidad
them
con el
peacefully
derecho
within the
internacional, como muy
forms
bien
of
nos
the
explicaba
international,
hace
how
unos
was
minutos el
explaining
profesor Juan.
our Professor Flack in terms of it.
Pero es que
But
además
also,
estos 120 conflictos armados en el
these armed
mundo
conflicts around the world
han acelerado
have
la carrera de
been
armamentos. La
accelerating
carrera de
the
armamentos
construction of
tampoco tiene
new
ningún
the
control.
war and
Y
new
según el
arms
Instituto
construction.
de Referencia del
And
Mundo
the
sobre esta
institute,
materia, que es el CIPRI,
CIPRI,
de Estocolmo,
from
el gasto
Stockholm,
mundial, militar mundial
the
en el año
expensive world
2024
expenses for war
alcanzó
has been
la enorme cifra de
is to be
2.718
$18
miles de millones de
billion.
dólares. Si el mundo se ha gastado
The
esta
world
ingente
have
cantidad
been
de dinero
sending the
en el
amount
año
of money
2024
into
y este año
2024
en
and in
curso
the current year
2025
and 2025
superará
is going to be
sin
more
duda
than that,
ese umbral alcanzado en el
that
año 2024,
amount that we reach in 2024.
lo que nos pone de relieve
And what we can see in this process right now,
es que esa carrera de armamento
that
tan
the
impresionante
arm race is
tiene
really
unos efectos
impressive,
demoledores
have a very
en el
demolishing
respeto con
effects
la violación del derecho
in
internacional,
terms of the
de los derechos humanos y del derecho
international
internacional humano.
human rights and international
Por darles un
peace
dato
rights.
reciente, en
This is a data
2024,
in 2024,
casi 300 millones de personas
300
en
million
53
persons
países del
in
mundo
53 countries of the
sufrieron
world
inseguridad
that were
alimenticia
suffering
aguda en
lack
contextos
of
de
food
conflictos armados,
during this war
crisis
conflicts.
climática y
They had
desplazamientos forzosos.
and they had forced displacements
Además, las
and
violaciones
conditioned the
masivas
climate. The
de derechos
massive
humanos y del derecho
violation of
internacional
human rights
humanitario permanecen
continue to be
generalmente impunes
general
en
have
contextos
no
bélicos.
impunity in context of these issues.
Esta es la
This
razón
is
por
the
la que nos
reason
encontramos
why we find
con que
ourselves
al asumir el presidente Trump
when Trump
y al dinamitar
became
el orden
and when
multilateral,
he
lo
actually
tenía muy
destroyed the
fácil
bilateral
porque ya estaba
order
todo preparado para que
when
eso
everything
pudiera ocurrir.
was getting ready to actually
El
do some work.
esfuerzo armamentista y bélico de los estados
The effort that of creating
se hace
arms
en
and
detrimento
war,
de la financiación eficaz
it
del desarrollo
creates a very
económico,
big
social y
problem
político,
to actually allow
y
the
también en
people
detrimento
to develop and
del
grow.
esfuerzo financiero que
And
requiere el
also,
combate
it actually
del
creates a
cambio
damage
climático,
to the
por
creation
lo
that
que
the
las
creation of war
desigualdades
does
económicas
to
y sociales en el mundo
climate, because
se
creates
han
this
incrementado
inability, is
exponencialmente.
created this inequality
El alto
and around the
comisionado de la
country, and it
Defensoría
has
por los Derechos
increased.
Humanos ha reconocido
We
que desde el año
recognize since
2020
2020,
alrededor de 5.000 millones de
5,000
seres
million
humanos,
human
es
beings,
decir, más de la mitad de la humanidad,
more than half
se
our
ha
human,
empobrecido,
have become poorer,
mientras que la riqueza de los
while
multimillonarios
the
aumentó
multimillionaires,
3 veces más
their
rápido
richness
en
has
2024 que en el
augmented
año anterior.
3 times more than in the year
También
before.
reconoció el alto comisionado hace escasas semanas ante el Consejo de Derechos Humanos que el consenso mundial sobre
The
los
word
derechos humanos
consensus
se
on
está
human rights
desmoronando ante nuestros
is
ojos, bajo el peso de los
going down
autoritarios, los dictadores
in our
y los
eyes
oligarcas.
in front of all the high ranked
Este
people.
planteamiento de crisis mundial me
This
lleva a la
word
segunda parte de mi
crisis argument
exposición,
leads me
en la que me interrogo sobre
to the
si la
next
ONU requiere
event,
una reforma o
that
realmente lo que
if
requiere es
whether
una
it requires a reform
refundación.
or a refund
Por lo
foundation.
siguiente,
So we
en
proceed.
2005
In
se cerró
2005,
en falso el último intento
in falso,
serio de reformar las
there was
Naciones Unidas.
the last
Fue el documento final
serious
de la
try to
Cumbre Mundial
reform
del año 2005,
the document.
que se
It was
limitó
in
a formular una
2025,
relectura
and it was
de la
limited
Carta de las
to
Naciones Unidas.
formulating a reading of
Lo
the
que en sí
UN
mismo no
chart,
fue baladí,
which itself
debemos de tener en cuenta
was
que en
free,
aquel
because
momento
we need to
predominaba
keep in
un
mind that by
contexto
that
de
time
crisis
there was a world
mundial muy grave
context,
que
general
había
crisis
acarreado
that
la guerra contra el terror de
had
otro presidente de los Estados Unidos,
led
en este
to
caso
another
el
war,
presidente Bush,
with
y
war,
la guerra ilegal
including Bush,
ilícita
and the illicit war
contra Irak,
against Iraq,
y contrario, por supuesto, a la Carta de las Naciones Unidas.
and it was against the UN Charter.
La consecuencia de todo esto es
The
que
consequence
es evidente
of
que
all of this is
falta
it's
voluntad
imminent
política
that we're lacking
por parte de los
political
estados
will
dominantes
on the dominant countries
para reformar
to
el statu
reform
quo
the
que
status quo
representa la Carta de
that the Charter,
1945,
that the 1945 Charter
carta en la que se había consagrado
had,
el gobierno del mundo
a charter that
por parte de un
was
directorio
part of the
compuesto
world
por
government
las 5 potencias vencedoras
that
de
was
la Segunda Guerra
composed by
Mundial
the winning
a
parts
través del derecho de
after the
veto
World War
del
II.
Consejo de Seguridad. Y que también, como muy bien nos acaba de
Through
recordar,
legislation, the
Paz,
Security
son
Council.
las
So
primeras
we must remember that
responsables
it was
del mayor número de armas
from there were
atómicas
the
en el mundo,
first, the top countries with more
pero no
atomic
las únicas.
weapons in the world.
Tales estados
Such countries
son contrarios
are
a los derechos de
contrary
solidaridad,
to solidarity rights,
tales como el derecho a la paz,
such as the right
al
to
desarrollo,
peace, development,
al medio ambiente,
environment,
al desarme, el derecho al patrimonio común de la humanidad,
no weapons, and the
y el
the
derecho de
rights
las
to
víctimas,
patrimony,
tanto a
humanity right, the human right to
asistencia
patrimony,
humanitaria
and the right
como
to
a ser
humanitarian
protegidas por la comunidad internacional
actions as to be protected by the international community
contra el genocidio,
against genocide,
los crímenes de guerra
war
y
crimes,
los crímenes de lesa humanidad.
and crimes against humanity.
La realidad es que la
The
Carta de las
reality
Naciones
is that
Unidas
the UN Charter
no se va a poder reformar nunca.
will
¿Por
never
qué?
be
Si
able
ustedes
to be
leen los
reformed,
artículos
because if you
108
read
y
the
109 de la Carta
108
de
and
las Naciones Unidas,
109
se darán
articles
cuenta
in the
de
UN
por qué.
Charter, you will
Porque
see
cualquier
why.
enmienda de la Carta de
Because
las
any
Naciones Unidas
amendment on
debe
the
ser
UN Charter
aprobada por las 2/3
has
partes
to be
de
approved
sus
by
estados miembros.
2/3
Pero
of its
en esa
member
mayoría de dos
states.
terceras partes tienen
But
que estar forzosamente
those
incluidos
states
los
must
5 estados permanentes del
must
Consejo de
have the 5 permanent
Y esa es
states
la
in
clave
the council.
que nos permite entender
And that's
por
the
qué
key
nunca habrá
that
reforma de la
allows
Carta de
us
las
to
Naciones Unidas.
understand why there
Los
will
5
never
miembros
be a
permanentes
reform.
no quieren ceder los privilegios que adquirieron en el año
The 5 permanent
1945
members
cuando se creó la
won't
Carta de las Naciones Unidas.
won't agree to that
Por
because it
consiguiente,
goes
ante
against
la
their wills.
alarmante irrelevancia actual de la ONU,
And
es necesario
facing the
reemplazarla por
alarming
otra
irrelevance
organización mundial
the
de
UN,
estados que
it must be replaced by
evidentemente
another
deberá ser
world
más fuerte
state
que la
organization
creada
that
en el año
has to be
1945
stronger
y dotada
than the
de
one
los
that was
medios
created in
necesarios para
1945,
hacer
with the
respetar
necessary
e
means
incluso imponer el derecho
to respect and even impose
La
human
nueva
rights
organización mundial
respect.
deberá
The
de
world,
ser más democrática,
the world
más supraestatal
organization must be most
y menos
democratic,
intergubernamental,
must be
que
based
es
on
lo
terms
que
and
es
not
actualmente la ONU.
intergovernmental,
De manera
which is what
que los
the UN
estados
now
estén
is,
representados
so that the states are
no
represented
únicamente por sus gobiernos,
not just by their
sino de una
governments,
manera tripartita.
but
Es decir,
in
cada
a
estado esté representado
three-way organization, which
representante,
means
un
that it's
representante del
represented by
gobierno,
a
un
government
representante del Parlamento
representative,
Nacional y un representante de
a
la
national
sociedad
representative,
civil del Estado por sí.
and a social
Eso nos
state
acercaría
social
a un modelo más
society,
democrático
civil
y real
society
de la
representative,
representación de los estados
and that
en
what
la Organización
would
Mundial que
improve the representation in the
Y esa
of the
composición
states.
tripartita
And that
debe ser
three-way
respetada
composition
en todos los
must be
órganos
respected
principales
in
y sus
all
subsidiarios
the
que se
main
establezcan en la
and daily
Organización
organs that
Mundial.
are
Y por
established.
supuesto también
And of
deberá
course,
crearse
it must also
un órgano judicial
a
mundial que a
world
diferencia de la Corte Internacional de
judicial
Justicia
organism must be
actual,
created, which in difference to
tenga
the
una jurisdicción obligatoria
international
todos
court, the
los
current
Estados,
international
y
court,
además sea
it would to
capaz
have the
de
obligation
ordenar la ejecución
to
de sus decisiones,
impose their decisions,
y no
the
confiar
execution
a
of
un
their decisions,
Consejo de Seguridad,
and
como ocurre
just
ahora,
not
la
trust a
posibilidad
Security
de
Council
ejecutar o de
to
obligar
be
al
able
Estado
to
a cumplir
force the
con una
state to
sentencia
comply
condenatoria de
with
la
a
Corte Internacional de Justicia,
sentence,
porque el Consejo de Seguridad
with the decision,
no
with the judicial
actuará
decisions, because the
siempre
Security
y
Council
cuando
never
los
acts
intereses de uno de los 5
unless one of the five
permanentes
permanent
esté
member states
en
are
derecho, en el caso concreto.
at risk.
El tiempo me lleva a
Time
cerrar esta
leads me
parte
to
para pasar a la
skip
tercera
this
parte
part
de mi
to
exposición,
go to the next
que
part of
se
my
concentra
exposition
en el
that is
derecho humano a la
focused
paz.
on human rights to
Nuestra
peace.
asociación, la
Our
Asociación Española
association, the
para el
Spanish
Derecho
Association
Internacional
for
de los Derechos Humanos,
Human Rights
promueve el
Association
reconocimiento
promotes the
internacional
international
de la paz como
acknowledgement
derecho
as
humano
peace as a
desde
human
el
right
año 2005.
since 2005.
Y a partir del año 2006
And
elaboramos
starting in
una declaración,
2006,
un
we
proyecto de
elaborated
declaración, que es la
a
Declaración de
declaration
Luarca
which is
sobre el derecho
the
humano
Luarca
a la paz,
Declaration about
que ilustra
individual rights
a
that
cualquier lector
illustrates
de esta declaración
the reader
cómo es posible definir
on
la paz
how we can
y
define
además
peace,
presenta
and it
los
also
elementos
presents
necesarios
the necessary
que
elements
deben de estar
that must
reconocidos
be acknowledged
para que la paz
so
sea
that
real
peace is
en
real
en el derecho internacional.
in international law.
En esta declaración de Luarca pusimos de relieve
In
que el
this
derecho a la paz
Luarca
debe de
Declaration,
responder a un planteamiento holístico,
we propose that it
integrador
must
y de
respond to the
síntesis
holistic
de todos los derechos humanos
approach and that
universalmente
integrates
reconocidos.
all the
Es
universally
decir, derechos
recognized
civiles,
human rights, so
culturales,
civil, cultural,
económicos,
economic,
políticos,
political,
sociales
social,
y derechos al
and
desarrollo
development
y al
rights,
medio ambiente.
and right to a fair environment.
Además, como muy bien también ha señalado el
And
profesor
as
Falk,
also Professor Falk has also
consideramos que la paz
pointed,
no,
we
no
consider that
solamente es
peace
la paz
is
negativa,
not just the negative
como ausencia de
peace as
conflicto armado,
absence of
Green Marjorie
armed
lo ha
conflicts,
indicado muy justamente. Por
but
supuesto que
of course
paz
that's
requiere la
that
ausencia de
requires
conflicto
the
armado,
absence of
la
armed
ausencia de
conflict
violencia
and direct
directa.
violence.
Pero además,
But
la
also
paz requiere
peace
una lectura en
requires
positivo.
a positive
La
readings,
lectura
a
en
reading in
positivo de
positive.
la paz
That positive reading
significa
means
combatir otras
fighting against
violencias
other
existentes en nuestra
violences
sociedad
that exist
internacional.
within our international
En
society.
concreto, la violencia
In
estructural que produce las desigualdades
specifically,
económicos
structural
sociales
violence
que dividen
that
el mundo
people
en
are
un
suffering
norte
and
rico y
which
un
and
sur
divides
pobre.
the world in
Cada
two
vez
parts, a
más
poor
y
side
un
and the rich
norte rico
side.
cada vez más
So rich people are always richer and poor people
y
are always
además
poorer.
la paz en sentido positivo
And also peace in the
requiere
positive
combatir
sense
la violencia
requires
cultural que está presente
to
en
fight
todas
against
nuestras
cultural
sociedades.
violence that is present in
Y basta con
all
poner
our
un solo ejemplo,
society.
la violencia de género.
And
La
there's
violencia
just
de género
one
nos
that
pone de
needs that
relieve
would make the
que la
point clear:
mitad de la humanidad
gender violence,
domina por la fuerza
which
bruta
means that
a la otra mitad
the
de la humanidad, los
strongest
hombres
part
sobre las mujeres.
of the war
Y eso
dominates the
no
weakest
puede ser.
part, and
No
that
podrá
cannot
haber
be.
paz en el mundo
There won't ever
mientras la
be
mitad de la
peace if
humanidad
when
esté
half
dominada
of the
por la
population
otra
is
mitad
dominated by the other
por medios
half
brutales, como
by
la violencia de
force
género.
and violence,
No puede
which is
haber paz en el
what
mundo
gender violence
mientras haya
is. There
semejantes
won't be
desigualdades
peace in the world
económicos sociales que condenan al
as
hambre
long
a
as we still have
850 millones de seres humanos actualmente,
hunger and
según
social
reconoce la
conditions
FAO.
in more than 12,
No puede haber
80,
la paz
18 million
pacífica
people.
mientras
There won't
haya
be peace in the
cientos
world
de conflictos armados
while there are
actualmente en curso
still
y que nos
these
llaman
armed conflicts
poderosamente, claro, la atención.
happening and nothing
Genocidio
is
palestino
being
y
done
mucho
to
más.
stop them. Palestine genocide and much more than that.
Además, nosotros nos preocupamos por señalar
Also,
en la declaración de Luarca
we
que es un
took
derecho
care of
profundamente
pointing
enraizado
out
en la Carta de
in the
las
Charter that
Naciones
it's a
Unidas, como muy bien puso en
profound
relieve
right
el profesor Farr.
in
y
the
también
UN
en la
Charter
Declaración
and also in the
Universal de
Universal
Derechos Humanos,
Declaration of Human
tanto en su
Rights,
preámbulo como en el
both in its
artículo
preamble
28.
as
Y
in its
además, la
28th
práctica de las
article.
Naciones
And also
Unidas
in
ha
the
quedado
UN
claro
practice,
desde el año
it's been clear that
45
in
para acá
1945,
que sin paz y seguridad
that without
no
peace
son
and
posibles
security,
ni el desarrollo económico y social
development and
ni el
social and
respeto
economic
efectivo
development
de los derechos humanos,
and effective respect to
lo que
human
pone
rights
de relieve
are not
la
possible,
interdependencia existente
which
entre los
proposes
tres
the
pilares
interdependence
básicos
between those
sobre los que se
basic
sustenta
pillars
la Carta de las
where
Naciones
the UN Charter is based on.
Me voy a referir rápidamente a la última declaración sobre el derecho a la paz
I'll
que
talk
se ha
quickly
aprobado en la
about the
Asamblea
last
General de
declaration
las
of
Naciones
right to
Unidas
peace that
en
was
el año
approved in the UN
2016.
in
En sus dos
2016.
artículos, su parte dispositiva, en sus dos
In
artículos de fondo,
its dispositive
la
part and
declaración se
articles,
limita a
the
afirmar
declaration is limited
que,
to affirm
y
that,
cito
and I
textualmente, toda
quote,
persona
that
tiene derecho a disfrutar de la paz de tal manera
all
que se
people
promuevan
have
y
the right to
protejan
enjoy the
todos los
peace,
derechos
and so
humanos
that
y se
all
alcance
the human rights are
plenamente el
protected,
desarrollo.
and those human rights
Se
include
añade otro
all
artículo
that are
que
currently in
los
development,
estados
and it
deben
adds that the
respetar,
states
aplicar y promover
must respect, apply,
la
and
igualdad y
promote
la no discriminación,
equality and no
la
discrimination,
justicia, el
justice,
Estado de Derecho y
and
garantizar la
rule of
liberación
law,
del temor
and
y la
guarantee
miseria
the
como medio
liberation
para consolidar la paz
from
dentro de las
war
sociedades
as a means
y
to
entre
consolidate
estados.
peace within society and among
Fin de la cita.
those among them.
Creo que queda
And I
claramente
think
demostrado
it's
con
clearly
esta lectura
proved with this
que la
reading
declaración del año
that the
2016 ni siquiera
2016 declaration
reconoce la paz como un derecho,
doesn't
menos
even
como un
acknowledge
derecho humano,
peace
y
as a
tampoco
right,
reconoce ninguno de
not
los
to
elementos
mention a human
constitutivos
right, and
esenciales
doesn't
del derecho humano a
acknowledge
la paz que la
any
sociedad civil
of the
reclamamos
essential
desde la sociedad civil.
constitutive elements that we as a
Por
society
eso,
demand.
creemos que con la
That's why
declaración
we
sobre el
believe
derecho a
that
la paz de 2016,
with the declaration on
la Asamblea General no ha
rights to
terminado
peace in
el proceso de
2016, the human
codificación
rights,
y
the
desarrollo
UN hasn't
progresivo
finished the
del derecho
codification and
humano a la paz en el ámbito de las Naciones
development
Unidas.
progress in the
Y buena prueba de
UN
ello son las
regards.
resoluciones que tanto la
And
Asamblea General como el Consejo de
a
Derechos
good point is
Humanos
that the
ha
resolutions
adoptado en
and
el
the Human
periodo
Rights Council
subsiguiente al año 16,
have
es decir, el periodo
postponed,
entre el año
which means that
2017 y actualmente el año 2023.
between
Porque
2017 and
todas
our
ellas
current year,
mantienen la
because
preocupación
all of
de la
them
comunidad internacional
keep
por cuestiones
the
relativas al
worries
derecho a
that
la
the
paz
international community
y
has
algunos de
for
sus
right to
componentes.
peace and some of its
También son
components.
positivas porque
They're
asumen
also
la
positive
visión
because
holística de la
they
paz
assume the
que
holistic
como sociedad
vision
civil
peace
siempre hemos
that
reivindicado
as a society we
y
have
reducen
always vindicated,
considerablemente la
and it
diferencia
significantly
entre la
reduces
declaración
the
del
difference
año
between the
2016 de la
declaration
Asamblea General y
in
las
2016
declaraciones propuestas
and
por
the
la sociedad civil
proposed
desde el año
declarations
2006
by
e
civil
incluso
society
por el
in
Comité Asesor
2016
del
and
Consejo de Derechos Humanos
the
en el año 2012.
Human Rights Council in 2012.
Nosotros consideramos
We consider
que hay una amplia
that there's
mayoría en la
a
Asamblea General favorable
vast
al derecho
majority in
humano
general
a la paz, que
to human rights
permitiría continuar la codificación
that will
y el
allow to
desarrollo
codify
progresivo de este derecho emergente, de
the
manera que se
development
puedan
and progressive
recuperar los
states of these
elementos esenciales
rights
del derecho humano a la paz.
to improve the situation of human rights to peace.
¿Cuáles son esos elementos esenciales? A nuestro juicio son los siguientes.
These are the following
En el
essential
preámbulo
stuff.
se debe de precisar
First of all, we
claramente
have the
cuáles
preamble.
son los fundamentos
We have to write
legales, los
clearly
fundamentos
what are the
jurídicos
legal
del derecho a la paz
fundaments
en
and
el derecho
the
internacional de los
key
derechos humanos.
elements of
Claras
legal international
denominaciones,
human rights.
claras
There is
referencias
clear
y
references,
fundamentación jurídica.
the foundation
En
of
segundo lugar, los
political of this stuff.
titulares de este derecho
The second part,
deben
if to
ser
the headlines,
reconocidos como
they have
tales
be
las
recognized that
personas, los grupos,
people
los
and
pueblos,
groups
las
and
minorías y la sociedad.
minorities and the whole humanity have to be
Tercer
recognized in
punto,
this
los
process.
estados
The
no
states,
deben
the third
imponer
point,
sanciones
the
unilaterales
states
a
should
otros.
not put unilateral sanctions to
En
other
cuarto
states. The
lugar,
fourth,
los estados deben
states should
fortalecer
strengthen
los tres pilares
the three fundamental pillars of the United Nations in issues of peace and human rights and development. Uphold those three pillars. Also, the state should facilitate the contribution of women to avoid controversy and actually to avoid any other issues after conflict. Above all, they have to avoid the war propaganda and to promote the right of people for self-determination. We have to reform the Security Council to ensure its democratization and that actually follows up the responsibility that are delineated on the United Nations Charter. Because right now, it's right now under imposed paralysis by the members that cannot fix anything. We have to also recognize the rights, the basic, and the controversy, and and that provision, if it's not going to follow the obligation of the states to disarm itself, there's not going to be the renouncement to the use of violence and the armed war continue and the armed race continue to proliferate. We have to respect, to actually renounce the use of force, and that's not going to actually deny the ways of peace. To implement the education for peace, and discrimination of a woman, and also cultural discrimination. We have to recognize the right to human in terms of the need. We have to recognize the right to oppose oppression of colonialism, foreign genocide, racism, apartheid, war crimes, private enterprises, military and security. They have to be responsible for the relationships that they have and violation of human rights that they may commit. The victims of violations of human rights, they have the right to know the truth and have reparations and receive guarantees of no repetition. The refugee have the right to actually claim the national status of refugee. Immigrants also have the right to have be able to use all the benefits of human rights with the rights to development and climate are basic right for human rights. To finish, the multiple planet crisis that we have compromises the three fundamental pillars that sustain the benefits of the United Nations: peace, development, and human rights. The states should actually respond to the ask of the human civil society. We have to evolve with the material content that they're asking as social society. We have to follow up with the Declaration Universal of Peace and the right of peace that was actually put forth in 2016 when Vajete and the people who actually represent their community to study and reflect in that text and to consider that text strongly. And I want to start with the last comment. The rights to solidarity include peace, include organization of global states with all the means needed to impose the rights of peace. The provision of use of force might be absolute in their relationship. The states should abolish their armed forces and disarm themselves progressively. In that way, the resources that have been freed will be dedicated to make sure that the basic needs of the populations are taken care of, the economic right and socials of the people. The principles of solidarity should actually substitute the principle of international cooperation. They should then recognize and apply the rights of solidarity, the right of disarmament, and development. I thank you for your attention, and I will be here to hear more from you or respond to any question. Thank you.
Muchas gracias, Carlos, for explaining the contradictions inherent in the structure of the Security Council, which prevents the realization of the right to peace, as do the economic and power differentials in the world, and your suggestions for changing that reality. Next, we have Jun Sasamoto. Jun?
Thank you, Marjorie. I will use a PowerPoint. Please. Okay. I will speak of about international political and legal implications of the right to peace through analysis of the deliberation of the United Nations Human Rights Council. First slide. In Ukraine, Gaza, Israel, and Iran, wars and conflicts are all waged by states' decisions, and these decisions disregard the United Nations Charter. The right to peace was adopted as a UN declaration in 2016. It recognized the right to peace as a right belonging to individuals, not to states. The concept of the right to peace has the potential to transform the sovereign state system and raises questions about the security concept. Security concept is often defined national security, and it is by and for states. Preamble of the UN Charter begins with "We, the people of the United Nations." It implies that quest for peace is in the hands of people rather than nations. The right to peace can be seen as a concrete step to realize this idea of UN Charter. The right to peace is not limited to legal rights, but also political rights. By invoking the right to peace, we can legitimize our demand for peace from their governments as an exercise of rights. And I am a lawyer, but I participate in the deliberation of the UN meetings and NGO meetings as an NGO member with colleagues, including today's speaker, Carlos Pianduan and Roberto Zamora. In that meetings, I was so inspired UN and NGO discussions that I enrolled in the graduate school of the University of Tokyo and wrote a doctoral thesis. And finally, in 2025, this year, I obtained a doctoral degree in the international contribution field. In this thesis, I position the right to peace as a powerful legal concept for realizing human security within the discourse of political science. Human security. The concept of human security was proposed in the UN Human Development Report in 1994. And it encourages us to view security not only from a state perspective, but from individual perspective. However, as this human security concept is a policy concept, so human security has been set as a list of human insecurities. From the point of critical security studies, UN concept of right to peace lacks theoretical clarification regarding what causes human insecurity and how states related to individuals. My thesis seeks to clarify these issues from analyzing UN Declaration of Right to Peace. For analyzing the deliberation, I also use the norm studies criteria. Discussions on the right to peace began in the 1970s within the United Nations. And 1998, in UNESCO discussion, the concept of right to peace was categorized into 3 rights. First is just an aspiration of human beings. The second one is a moral right. The third one is an established human rights. But intensified deliberations started in 2008 in the Human Rights Council. I utilize the standards of academic norm studies. I can point out that 3 key points were shared among favored countries in the UN discussions. The first one is the right to peace was framed as a right of individuals rather than states. The second point is right to peace was also debated as a right to demand against international institutions, norms, and structure. Third point, it was recognized as a right that could hinder the exercise of national self-defense. There are 3 disputed points in the UN deliberation. The first one is individual right or collective rights. Initially, the right to peace was presented to the Human Rights Council as a collective right by the Cuban government. However, during deliberations, Western countries rejected the idea of collective rights. They argued that collective rights were rights between states, not a human right. Consequently, the language adopted by the UN General Assembly did not include people's right, and concept of rights shifted toward individual right. Second disputed point is right to norm, institution, construction. The United States government argued that the right to nuclear disarmament should not be included in the right to peace. The United States insisted it should remain a matter of bilateral negotiations or UN organizations like Conference on Disarmament. However, this US stance indicates that if the right to peace is established, right to peace could undermine the dominance of the negotiations by great power countries and the international system and structure dominated by the major powers. Conference on Disarmament has a veto power for major countries. The third disputed point is relationship with national self-defense. Since 1970s in the United Nations, Western countries have maintained that the recognition of right to peace would conflict with the exercise of right of national self-defense. It is in the Article 51 of UN Charter. However, this argument conversely demonstrates that the right to peace can serve as a constraint on a national right of self-defense. This discussion of the UN deliberation, I analyze these UN discussions from the perspective of crucial security theory. And I suggest that right to peace can take priority over national security in some cases, and that right to peace has a possibility to change the current international institutions and structures. And right to peace also highlights the obligation of states to uphold peace for individual benefit. So states don't have complete freedom of military action against individual life. Content of the right to peace, we can see concrete content of the right to peace in the documents such as NGO Larca Declaration, Santiago Declaration, and UN draft from the Advisory Committee of Human Rights Council. Although these drafts were not formally adopted in UN, These draft declaration represents the concrete content of right to peace. Okay. I can categorize the right to peace into three groups from the perspective of challenging the state monopoly over security. Category 1 is right involvement. This is right for individual involvement in state decisions. For example, individuals' consent for military actions by states, or the right to involvement of women in decision-making of states. Category 2, right to demand positive action from the government. It is right to demand positive peaceful actions and resolution from states. And for example, right to demand dialogues with neighboring countries from the state. Category 3, right to demand inaction from the state. It means right to live in peace without state interference. Category 3 is a right to demand inaction from the state. They can be shown in court decisions in Japan. In Japanese court precedents, the court has recognized right to live in peace, not to be attacked by enemy nations. In this case, residents around the military base demanded not build a missile base. Or in other precedents, judicial precedents, right to live in peace refrain from participation in military actions. In this case, ordinary citizens demand not to participate in Iraq War. And in South Korean court precedents, right to live in peace was recognized by the court. In this lawsuit, residents around the U.S. military bases demand not to build new military bases in Pyeongtaek. These judicial cases shows the concrete light of Category 3. And most of the international treaties and agreements prioritize states' interest, and they leave little space for individual involvement. However, international human rights law has provided the ground for individual interest. In the war and peace field, the Hague Peace Conference in 1899 recognized individuals' benefits apart from states' benefits. Afterward, this conference developed into the international humanitarian law and philosophical basis of the right to peace. In the current conflict in Ukraine and Gaza, Iran, decisions to wage war are made only by states, and they render civilians as victims. The people can indirectly reflect its voice on policy only through elections. But even if policymakers are elected democratically, citizens do not consent to all policies. That is a fundamental contradiction between states and individual interests. But individuals have a right to peace. It means right to peace can empower individuals to demand accountability legally from government regarding military actions. States have obligation to individuals. As a result, the right to peace imposes restriction on the state discretion. For the future development as a legal right to peace, I suggest 3 points. One is implementation of existing practice within every countries. For example, invoking the existing law and constitution like Japanese code, or to claim an interpretation of the constitution like South Korea or Costa Rica. These countries have not the clear provision of right to peace, but court interpret and make a right to peace in the court decision. The second point is incorporate into domestic laws. For example, every country enact the law or constitutions in their own law system. The third point is action towards the international treaty to formalize the rights. It is, for example, in the UN level, we should aim to establish a human rights treaty on the right to peace. These are my suggestions. That is all for my speech. Thank you for hearing me, especially for Japanese friends until such a late midnight. Thank you very much.
Thank you so much, June, for your analysis of the deliberations on the right to peace in the UN Human Rights Council, the rejection of the right to peace as a collective or people's right, and the progressive aspects of the right to peace that were also rejected during the deliberations, and your suggestions for moving forward. Our final speaker is Roberto Zamora, who is joining us from the peace boat that is currently in Panama. So Roberto, happy to have you with us.
Thank you. Thank you, Marjorie, Carlos, and June for. As requested, I will try to bring a different perspective on how to understand the right to peace in practice through the unique case of Costa Rica, which is a case that I believe has been underestimated and underrated by the subject of deeper study, because it's the proof that it is possible to move forward in the direction of international peace, and what members of the international community under the understanding that the core principle that makes the whole international reasons why the international system is not working is because most of the states are not. We'll see through my presentation how in possible and these has to start with my presentation. I will follow screen. So following the some of what was said by Richard, Carlos, and Yoon, the concept of peace is not simple. Initially, it was entirely linked to violence, in particular to armed conflict. And through the discussions at the United Nations and different fora, it has been developed in the sense that peace is not just the absence of war, because there are other forms of violence that are not related to armed conflict. As Professor Villan Duran pointed, the lack of food security, the lack to access to medical service, the lack to economic equality are all forms of the structural violence. So it is of my opinion, through the combination of two core principles that are included both in the UN Charter and the universal. So if you ask me, what do I understand for peace? All human rights are fulfilled and enjoyed in an environment free from fear and want. Of course, free of all forms of structural violence. Let me move forward. Okay, now in the case achieved through an exercise of sovereignty and all right, it in Costa
Roberto,
Rica
you are
has
fading. Roberto, you're fading in and out.
always taken steps voice, or is also the video?
No, the video is fine. It's just that your oral presentation is there's kind of a delay. Is there anything you can do about that to make it smoother?
Using a headset, maybe I can remove it and try without the headset.
Okay, try that.
Let's see if this works better. So, as I was saying, the right to peace in the case of Costa Rica has been a historical construction, and its recognition by the Supreme Court and incorporation into the Constitution has been also understood as Costa Rican people have decided that we want to live in peace and without any international a thing. So if we look at the history of Costa Rica, we can see that throughout history we have endeavored to reach this ideal. For instance, unlike any other country in Latin America, after independence, Costa Rica did not elect a military man as a first head of a state, but we elected a elementary school teacher. And this is already a massive separation from the course that other also demonstrates the importance on education as a paramount principle for the construction of a peaceful constitution. We incorporated education as free and mandatory, and the government decided to start a policy to build schools in every single community and train teachers to bring knowledge to the pupils and the children in Costa Rica. Costa Rica was one of the first states to prohibit the participation of military men in politics and government. This was incorporated in the 1871 Constitution, which constitution that by a amendment in 1877 incorporated the proscription of the death penalty. Costa Rica became the third country in the world to abolish the death penalty, following the examples of San Marino and Venezuela. Then in 1949, the army was constitutionally abolished, although it had already been abolished the year before in 1948, meaning that in 2028, Costa Rica will celebrate 80 years without having an army, showing that it is possible to live and sail within the international concert of nations without the existence of the bellicose apparatus. This allowed for Costa Rica to be the seat of the negotiations for the Inter-American Convention on Human Rights, which was adopted in 1969. And Costa Rica is currently the seat of the Inter-American Court of Human Rights that yesterday delivered an amazing advisory opinion on the duties related and derived from the right to a healthy environment. In 1983, Costa Rica declared neutrality as a unilateral act of international law, although Costa Rica has always been neutral since independence. In the 2004 ruling, the Supreme Court prohibited the support of forceful actions without UN approval when it reversed the decision of the Costa Rican government to support the coalition of the willing that invaded Iraq, in a case that I'm very happy to say that's a case I brought as a university student before the Supreme Court. And then in a second case, as Marjorie mentioned in the introductions, the Supreme Court also ruled on a case against the decision of the Costa Rican government to authorize the manufacture of nuclear weapons in the country. It was also in this ruling that the Supreme Court recognized the existence of a right to peace within the constitutional framework of Costa Rica, but moreover, taking into account all this history, the Supreme Court recognized that the right to peace has been the free and wise decision of the people throughout history to self-determine as a peaceful nation. So I plan the presentation brief because, as Marjorie pointed, I am in on the boat and internet is limited. So as you can or might recall, in 2003, the United States and the UK led a coalition of the willing to give some legitimacy to an illegal invasion, which was the invasion of Iraq. Costa Rica was one of the countries called to join the coalition, not because of its military might, because we don't have, but because of the moral authority that Costa Rica has developed throughout the years in terms of peace, democracy, and human rights, which were the arguments initially given by Bush to initiate this invasion. So the whole purpose of having Costa Rica in the coalition of the willing was seeking for political legitimacy rather than military might. Not to say that being the United States the most powerful military in the world, it is little what other countries could bring or help the United States to increase this military capacity. Now, in the case, I argued that the support given by the Costa Rican government was in violation of international law, in particular, the unilateral declaration of neutrality, because as a unilateral act of international law, it is binding to Costa Rica. There is nothing in the international corpus juris preventing states to engage in unilateral obligations as long as they don't violate rules of jus cogens, rules of customary law, or general international law. So it falls within the Lotus principle and the Wimbledon principles to have the freedom to engage in unilateral obligations. Costa Rica decided to unilaterally oblige itself to be neutral. Then I argued that Costa Rica was in violation of the UN Charter by supporting an action, a forceful action that was not sanctioned by the Security Council. By the time the United States and the United Kingdom invaded Iraq, the Security Council has not authorized such action. Resolution 1441 never authorized the invasion of Iraq. And then I argued that there was a violation to a right to peace, but the court didn't fully agree on the existence of such right at the moment. However, the court did recognize that peace was a guiding principle enshrined in Costa Rica's non-written constitution. Costa Rica has a binary constitutional system composed of our written constitution, but which is strengthened by the developments of our non-written constitution. It's one of the few countries having such a constitutional framework. And in the 9992-04 ruling from the Supreme Court, the court wrote what I am quoting here in the slide, and instead of reading it, I will allow 2 or 3 minutes for you to read how the Supreme Court encapsulated this history of the Costa Rican people of sovereignty and self-determination in the understanding that without peace, we have nothing. So I will allow 2 or 3 minutes for everybody to read the quoted text and for the translators to make the translation. And then I will continue. So it is crystal clear from the text of the ruling that peace under the conception of the Costa Rican people is an achievement for which we have endeavored throughout our entire history as an independent people, that it is not random, that is not a random situation. We have endeavored for this, we have strived for this, and it has been our sovereign decision to decide to live free from the scourge of war. And in this process, we decided, when abolishing the military, to take the monies and the funds that otherwise would be used in weapons of destruction for a higher purpose. So we diverted the funds of the military to healthcare and education. So people will learn that violence is not the way to achieve development, that violence is not the way to achieve a higher living standard. And as of today, Costa Rica is the living example that you can achieve a high living standard if you use the money for the fulfillment of human rights and needs. I am the fourth generation of Costa Ricans living without an army. In my mind, there is no room for a military. We don't need it. We don't want it. And the sole question of whether or not Costa Rica should reinstate the military is incomprehensible, because we have lived the way we have lived for the last 80 years without having that image of violence and the bellicose apparatus embedded in our mindset. It doesn't even exist. It's out of a question. And this is a massive achievement for a country that is now defenseless. We made a gamble and we trusted in the international legal system when we joined the United Nations. And we decided that we were going to take any blow, but we were not going to return the blow, as the Nicaraguan 2010 invasion of Costa Rica demonstrated. Nicaragua invaded Costa Rica in 2010, and we did not fight back. That's why you never read news about the Nicaragua-Costa Rica war. We went to the court because that's why we joined the court. That's why we joined the United Nations. And because we understand that without this gamble in good faith, the international community is not going to achieve peace ever. Then, because I do not want to run out of time, and it's already going really quickly, in 2006, the Costa Rican government authorized the manufacture of nuclear weapons in Costa Rica, and I filed suit before the Supreme Court insisting on the existence of a right to peace that was actually a customary rule of domestic law constructed by consistent state practice and by the opinion juris clearly established in the Neutrality Declaration of 1983. And here, the court finally accept my theory in terms that Costa Rica had built throughout history a legally binding commitment to the recognition of peace as a right, not only of domestic, but also of international dimension. Peace is a human right. Either we all have peace or nobody has peace. But peace is not a partial thing. Either we all have it or nobody has it. I cannot go to bed in peace knowing about the ongoing genocide in Gaza that has been ongoing for over 50 years. I cannot go in peace knowing that I cannot go to bed in peace knowing that the amount of money wasted in weapons that Professor Villan Duran gave us the figure is more than the amount of money that we need to reverse climate change, to bring food to every person in the planet, and to bring education to every person in the planet. And once again, just because I think it would be disrespectful from my side to mess with the fantastic wording that Costa Rica's Supreme Court used in this 2008 ruling. I'm quoting the text and I'm giving you some time to read it so you can realize how peace is a conscious decision of the government and the people, and how peace can be used as a tool, as a legal tool, to remind our governments about our duties, our domestic duties and our international duties, to remind, in my case, the Costa Rican government that we have made decisions in good faith. And if we don't apply this good faith in the establishment of policies for friendly and peaceful international relations, then it makes no sense being part of the international community. So with this, and just allowing yourself some time to go over the text and the translators to go over the text, I will finish my presentation. I'm aware that I am running out of time, if not that I already ran out of time, and give room when Marjorie says so to finish my presentation and continue with the discussion and the questions from the panel. So this is what Costa Rica can bring to the debate. And in simple terms, is a dose of reality. It's not a dream. It's not impossible. What we really need is to act in good faith, be coherent with the solemn promises or the sacred promises Richard pointed at the beginning of the lecture. But moreover, that it is possible and achievable We just really have to work for it, want it, and be coherent, acting in good faith towards the other countries in the international community. So Marjorie, whenever you decide it's enough time, we can move to our next part of today's session.
Thank you so much, Roberto. And while people are reading this very important quote from the nuclear weapons case in Costa Rica, I just want to thank you, Roberto, for fleshing out the real parameters of the right to peace and explaining your cases in the Costa Rican Supreme Court that enshrined the right to peace. You give us hope. So let's just take a minute or two to read this quote from the Costa Rican Supreme Court, and then we will begin our discussion. Okay, let's get started with a brief interchange between the faculty members, and then at the conclusion of that discussion, we'll move to your questions, the questions from the registrants. So do any of the faculty members wish to comment on each other's presentations, make other comments, or do you have any questions for each other? Richard, yes.
Yeah, I have a question for Roberto, who very lucidly depicted the Costa Rican experience. And I wonder why what his view is as to why other countries haven't adopted a somewhat analogous approach to the combination of opting out of the war system and improving the prosperity of their own society. It seems like such a compelling combination of issues, and especially for a country that has is not a big factor in geopolitics. Why hasn't Costa Rica found others to join its crusade for a peaceful world?
Thank you, Richard, for the question. I think it's partially a sociological process. As you mentioned in your presentation, very sadly, strength, violence, and war is embedded in the mindsets of many peoples, mostly people of the powerful countries. It also has to do with, in my opinion, with an absolute misconception regarding security and the role of armed forces. After the United Nations Charter, war became illegal. The use of force became illegal, Article 2.4 of the Charter. So the only legal purpose of armies nowadays is self-defense, correct? Because war of aggression is illegal. So the only legal purpose left for national militaries is self-defense. But if we go to the practical analysis of the situation, having an army does not guarantee self-defense. If Costa Rica would reinstate its army, it would have maybe a 10,000 men strong military, with our economy maybe one jet fighter and a couple of tanks. That is no defense capacity. So we were doing a ridicule by thinking that the existence of an army itself signifies that you have defensive capacities. Moreover, that role of maintaining international peace and security has been given to the United Nations through the dysfunctional Security Council. So the issue here is of choice. And in the case of Costa Rica, since historically, throughout our history, we have always been reluctant to solve disputes by force, even domestically. The natural choice for us was understanding that investing money in the military was nonsense. Now, it is a great question why other countries, after seeing the example of Costa Rica, acknowledging that it is possible for a poor country to achieve high living standards without the recourse to a military, that Costa Rica has not seen a coup d'etat precisely because we don't have a military. They haven't followed suit. That is a fantastic question that should be asked to all other states. But you are, as I said at the beginning, you know, we live in a world where colonialism and racism are still very much present. European states, United States, and other powerful claim this moral superiority. So they are quite patronizing to any example or idea that doesn't come from them. And this is why the case of Costa Rica is always minimized and underrated. So, for instance, I'll give I wrote my thesis on permanent neutrality, having Costa Rica the best. I read hundreds of papers by European and American academics. Not one paper not one. So we have to get you have written a lot about this, Richard. You know about this much better than I do. Actually, I love your papers. But yeah, I just think that it would be good for the international community to take Costa Rica more seriously, because it seems to be the only country willing to walk in the right direction.
Thank you. Thank you.
Are there other comments by members of our faculty?
From me,
Yeah.
I want to ask Carlos. Carlos Association, Spanish Association has been promoted right to peace in the UN Human Rights Security since 2010, 2008. But after the 2016 UN General Assembly adopted the UN Declaration, we can see the progress after that to concrete the right to peace towards the international human treaty. So, what do you think about the plan or strategy to go to the further to the international human rights treaty? If there is some, please let me know.
Thank you for your question. I think that you're right, and we join you in your proposal of getting through a UN multilateral treaty dealing with the human right to peace. The problem is that there is not realistic right now. It is not realistic because before the treaty, we need to have some consensus occur, some consensus accepted by the majority of the states on a draft universal declaration on the same issue, and then moving to a treaty since or once the universal declaration will be adopted. I mean that we are proposing a similar path as we did in the past with human rights in general. First, the Universal Declaration, and then we move to the covenants and other international treaties adopted by the United Nations and other regional organizations. So, in the issue on the issue of the human right to peace, being conscious that there is not a consensus in the international sphere because a minority but very important number of states deny the right concept of the right to peace. This refusal from this important number of states does not amount to a majority which cannot preclude the General Assembly to go ahead in legal terms. But yes, as the International Treaty of the Prohibition of Nuclear Arms showed to us. But it's quite clear that there is no consensus on the issue. There is no consensus because, unfortunately, international relations are dominated by a small but very important number of states, in particular the United States and its allies from NATO, that are completely opposed to accept the idea of the right to peace. And with this in our mind, we understand that we can try to continue the codification process of the human right to peace and the United Nations, but we also realize at the same time that we need a new international organization, a new United Nations organization with a more consolidated democratic structure, with a new Security Council, taking into account or keeping the main principles of the United Nations Charter that to us continue to be completely virtual and actual, but at the same time keeping the international organization with powers and competences enough to make the decisions, for example, by the International Court of Justice, enforceable, or giving the Security Council the possibility of taking actions and decisions in accordance with the obligations that the Security Council has to deserve in accordance with the UN Charter. And this will require, of course, changing the composition of the Security Council and reviewing the veto right of the P5 countries. This is quite clear to us. So it's possible to continue in legal terms, but the politics are clearly against the progress of the legal codification. Politics are, on the contrary, putting us in an international crisis of so important dimension that we could go back to the 1945 UN Charter before that. I mean that the crisis is so critical, is so important, and so generalized that the international affair cannot permit the progress of a smooth international codification of the human right to peace as we are promoting as civil society members.
Any other?
So that, sorry, just to finalize, if there is no, just to finalize, to conclude with your main question, if there is no actually possibility of progressing in the international codification of human right to peace as a declaration, we cannot even think on introducing the idea of codification of an international treaty, because the international treaty will signify that more obligations have to be taken by states, international obligations taken by states in the international arena in a situation in which clearly the international arena cannot accept more of the international obligations in this area, unfortunately. Thank you.
I also think at the discussion in the Human Rights Council in 2016, I felt that the declaration did not reach a consensus. One factor is there are very few national practice in every countries. So there is no basis to push up to the International Human Rights Treaty. During I studied doctoral thesis for about 8 years. Only national practice in the internal court decision is Costa Rica, Japan, South Korea, maybe 3 or 4 countries. Very few. Especially In the Western countries, in the Human Rights Council discussion, opposed countries, United States and Canada and European countries and Japan and South Korea, they are all covered by US military alliance. In these Western countries, we should promote national practice, especially in the court decision. We should once we should take back from the UN stage to the every country's internal stage and make many national practice and go back to the United Nations for international human rights law. So it may take many times, but it is the most reasonable and achievable procedure, I think. Thank you.
Thank you, June. Now I would
You
like,
may,
I'm sorry. Go ahead, Carlos. Yes.
yeah, just I can join the purpose of June, or the June purpose on this point. I mean that the legal development of the right to peace, or the human right to peace at the domestic sphere is completely necessary anyway. As Costa Rica showed, Colombia also, in the Constitution of Colombia, the right to peace is also recognized, but at the same time, there's an internal armed conflict, ongoing internal armed conflict in Colombia that does not match with the recognition of the right to peace at the constitutional. This is the reality in Colombia. In Costa Rica, there is no an internal armed conflict, fortunately for Costa Rica. But Costa Rica has at the north and south important armed conflicts, the ongoing armed conflicts in Nicaragua, for example, or in Honduras, or in El Salvador, or even in Panama. There is a lot of civil unrest around Costa Rica. So it's very difficult, but Costa Rica is right that it has to continue to upheld the right to peace as a part of their constitutional and constitutional right, their own constitution, both written or non-written constitution, as Roberto explained. That is correct, and this is very good. That will be an example that should be followed by other states. It's possible. It's possible being a state in the international community without arms. It's possible. Costa Rica is a clear demonstration that this is possible. But unfortunately, the internal or domestic dimension does not match with the international reality, with the international dimension. At the international dimension, unfortunately, we are in a so important crisis that the idea of the human right to peace is not accepted by a number of key states, dominant states in the international arena. That's the problem. The United Nations and members of NATO do not accept even discussing the idea of the right to peace. That's why there is no consensus on the issue. And there is no progress. There cannot be progress, real progress in the international arena with this standing position by the United Nations, by the United States and its allies from NATO. That's the reality, to my view, of course. Thank you.
Thank you, Carlos. I want to move on now in the remaining time to questions from our attendees. First, should the United Nations, either the Security Council or the General Assembly under Uniting for Peace, send a coercive force to secure a settlement in Gaza? Do any of you want to respond to that question?
Yes, and the General Assembly tried several times using the precedent of the Unite for Peace resolution. But the problem, the crucial problem here, is that the United Nations does not have enforceable power to impose any decision to Israel. So that the resolutions adopted by the General Assembly are not enforced, and if Israel is not ready to accept it. And this is the case. Neither Israel nor the United States are ready to accept any resolution adopted by the General Assembly forcing Israel to withdraw from Palestine and to stop the genocide, the ongoing genocide. That is the reality of international law, unfortunately, so that the General Assembly cannot substitute completely the Security Council because the only body legally authorized by the Charter of the United Nations to take enforceable decisions is the Security Council and not the General Assembly.
Okay. Considering the clever way the US government uses human rights and democracy in its funding of the National Endowment for Democracy and its foreign policy in general, how can human rights activists in the US use and focus on human rights in ways that don't reinforce US geopolitics?
The question is addressed to me?
Anybody on the faculty? Does
Can
anybody?
can you repeat the question?
Yes. How can human rights activists in the US use and focus on human rights in ways that don't reinforce US geopolitics?
After the UN declaration in 2016, every country should take into account of the UN declaration right to peace. So even in United States, they can invoke the right to peace, but right to peace is a very ambiguous concept. So we should elaborate that right. For example, in the United States, the questioner mentioned about NED, National Endowment for Democracy. That organization use budget for military purpose or interference purpose. So as a individual, objectively, we have right to demand the not to use budget for military purpose or interference of the other countries. In Japanese case, our Japanese lawyer always elaborate the right to live in peace in some concrete cases. For example, in the militarization of Japan, current militarization of Japan, we are now using the right to live in peace elaborated to right not to be deprived of resident land for military purpose, etc. We can invoke that kind of right in the court, and it is immediately accepted by the court, but some some court can adopt some kind of right of peace. So we can every country's peace activists and lawyers should elaborate this right to peace for national practice.
Thank you, June. Some experts say that it is the development of new types of weapons that lead to new wars. Should we direct our efforts to stopping arms production and shipment the way Palestine Action does? Anybody want to respond to that? Or perhaps that's just a suggestion for a tactic.
I think that we all agree on that. Of course, if we wanted to have Israel stopping the ongoing genocide in Palestine, one of the measures that have been, for example, advocated and proposed by the Special Rapporteur on the occupied territories, Professor Francesca Albanese, is that all states should avoid trading and all kind of armaments with Israel, and all trade agreements should be cancelled or suspended in order to cut the possibility for Israel to continue bombing and using arms that are provided by United States and other European states also. That's quite clear. The problem is that there is no international infrastructure or international body that could control the sanctions to be effective. Sanctions have to be adopted by the Security Council. And again, a decision on sanctions against Israel is always vetoed by the United States. So there is no sanctions that could be adopted against Israel by the Security Council. And this embargo of the armaments to Israel will never be adopted by the Security Council. That's why the international community does not have means to impose even the advisory opinions by the International Court of Justice that are asking clearly Israel to withdraw from occupied Palestinian territories and to recognize and to repair the Palestinian population. Even those advisory opinions adopted last year by the International Court of Justice are unmet by Israel. Why? Because there is no unenforceable decision by the Security Council that should continue the advisory opinion to make it enforceable against Israel. It's always the same problem. Security Council.
Roberto?
Yeah, if I may, I just cannot agree with the underlying premise of the question. And might to wage war will do so. And it does not depend on the development of new weapons. As Professor Carlos pointed out, there are 100
instead of presentation. Sorry.
Sorry?
Go ahead, Roberto.
Yeah. So as Professor Carlos pointed, there are about 120 armed conflicts ongoing in the world. none of them, not all of them, are created because of the development of new weapons. It's more a matter of, I mean, if you want to fight, you're going to fight. And if it comes down to fists, it will come down to fists. So it's the development of new arms that, of course, should be coped. Concerning the Nicaragua case, pointed that there is no international general law coping the amount of the size of a military, or even whether or not a state have or can have a military, or can, or like the case of Costa Rica, can demilitarize. So I have a problem with the basic premise of the question. We can still have a war with sticks and stones. It is it's not the the weapon that determines reasons actually led to these armed conflicts. But I don't think the development of new armed conflicts is dependent or correlated to the development of new wars. So I really have a problem with the underlying premise of the question.
Okay, well, thank you so much. We're coming to the end of our time. Unfortunately, I want to thank our faculty, Richard Falk, Carlos Vianduran, June Sasamoto, and Roberto Zamora for your excellent presentations. Also to our administrator and our interpreters and our task force. The next program of the People's Academy of International Law will be a course on the rights of refugees, asylum seekers, and other migrants. It will take place on August the 7th, which is a Thursday, and the faculty will include Camilo Perez Bustillo, Nicole Phillips, and several others. So thank you again to all of the people who registered and attended this program, and we will see you next time. Thank you so much.